there's 6 different deeds where they're just removing each other. That's actually a father and son. The father seemed to have difficult relationships with all of his children. One piece of advice I'd give to practitioners is don't make the family patriarch the protector, no matter how much he wants to be. Get someone who's not a family member but very trusted, precisely so that this kind of stuff doesn't happen. I know that he wants to retain control, but it's not a good idea as a matter of practice, because if a relationship breaks down, if a family breaks down, you then get this kind of a fight about it. And I feel that Australian law is not so good at dealing with it.
Hello, everyone, and welcome to today's episode of Trusts Talk, a podcast with Mark Bennett and Adam Hofri.
And today we are really delighted to welcome as our special guest Professor Katy Barnett, who is a professor of law at Melbourne Law School. And in terms of introducing her range of scholarly interest and output is very impressive. She publishes a huge amount, including textbooks on remedies law and other related aspects of private law. Areas such as disgorgement of profits, calculation of damages in common law and statutes. She publishes really interesting stuff on comparative law, legal history, often in the area of animal law, a book called Guilty Pigs that she co-authored. And I've seen publications on bee law. There's a huge array of fascinating topics that Katy can talk about. But for this podcast, we're going to focus on trust law and really interesting recent work that Katy has done on protectors and settlor control. And I'm just as a sort of personal note, it's really lovely to have two of my cold call email collaborators in this podcast episode, because both Adam and Katy were people that I reached out to. I think it might have been a Twitter direct message to Katy saying, oh, you're doing such interesting work on this topic. And then we've chatted back and forth, and then publications and collaboration and friendship have followed. And so you two are examples of networking without being at a conference, without jumping on a plane, which sometimes can work when you email someone with a common interest. It's great to be on the call with both of you. So yeah, welcome. We're really delighted to have you on the podcast, Katy.
It's such a pleasure to talk to some of my two favourite trust people. So
I mean, continuing on this note, speaking of the global community of trusts scholars and trusts practitioners, which is very strong, it is a global community. However, of us three, two hail from the antipodes. And this is not a coincidence, because one thing my global travels have shown me is that Australia specifically is really a stronghold of trust law, trusts scholarship, and trusts practice. So our first question to you, Katy, is why do you think that is the case?
I'm so glad you asked, Adam. I get to raise my dodgy convict ancestors in response. So, trust me, this has a point. No pun intended. So, it's interesting. I've been recently looking at the beginning of trust law in Australia and how it became such a strong area. And what this led me to discover is that one of my putative ancestors created a trust furor when he died. He created a testamentary trust. There was clearly a power to do so. And the beneficiaries were his convict concubine and her 5 children. So he left all his property to her and legitimated the children. They weren't married, no. So, so far, so good. But then it turned out what he'd bequeathed to her was debts. The 2 trustees of the trust were not looking after the trust property. Instead, they were rebelling against Governor William Bligh. It was a very Australian rebellion. So they rebelled over rum. It's called the Rum Rebellion. And the way in which it transpires is the most Australian thing ever. The army marches on Government House. They pull Governor Bligh out from under the bed. In another country, you might think Governor Bligh is dead. No. No, they pull him out from under the bed. They put him on a ship in Sydney Harbour where he sits for a year and writes angry letters about the legitimacy of the coup and asks for a copy of Blackstone's Laws of England, which one of my convict ancestors gives to him, even though he was a member of the coup. So anyway, that's by the by. But then what happens is the 2 trustees are busy rebelling. So the governor appoints someone else to be trustee. And he's like, I'll sell off the property and I will try and get rid of some of these debts. It's unsuccessful. But for 20 years, an English settler is the owner of this property. And then the convict concubine decides, I shouldn't have sold that land. I want it back. So she hires a barrister called William Charles Wentworth, quite famous, and he takes it to the New South Wales Supreme Court. Now, under current law, if you tried to rescind a sale to a bona fide purchaser for value without notice, after 20 years particularly, what chance would you have? None. However, the court says, oh dear, the orders by the governor and the judicial order pursuant to which this trustee sold the land, the judicial officer did not have equitable powers at that time. So this transfer to this English guy for 20 years was invalid and the sale is rescinded. So my ancestors get the property back. But then everyone in the colony is like, oh my goodness, this is a disaster area, because who knows what transactions are going to be rescinded if we don't have a law of equity. So what then transpires is that there's a 20-year legal fight in which my ancestors get all the land, but they end up having to sell it off because everyone was in debt all the time, even the judges. And in the end, the Parliament says this is unacceptable, and it appoints a judge in equity in New South Wales. I don't think it's chance that the judge in equity was appointed just after my ancestors' matter settled. So you've kind of got my annoying convict ancestors to blame for the fact that there's a judge in equity in New South Wales. So from having rather shaky start to the beginning of trust law in Australia, what we then have is a move to being absolutely the most orthodox, the most strict, the most rigid trust law, because we do not want things like my dodgy ancestors to happen again. Bona fide purchaser for value, equities darling, across the board. They developed the Torrens system, none of this rescinding contracts of sale of land. So we kind of go to the other extreme. So the initial colonisation of Australia, utterly chaotic, no one knew who owned what. And we kind of, after about 40 years, we switch. We become totally orthodox and actually kind of obsessed by equity. So I think historically, that's actually why Australia is the way it is. It had a period where it wasn't sure about trust law. It actually had no lawyers other than two convicted perjurers. And the people it appointed as judicial officers were just random army people who had a copy of Blackstone's Laws of England. And it wasn't even in date.
So now, obviously, you've got some real giants of equity writing these august textbooks. The status of equity and trust is very high within the Australian academic and legal profession. In New South Wales, is there still an equity court?
Yes, so there's still a judge in equity. Now, interestingly, New South Wales did not fuse its courts of equity and common law. So everywhere else, England, all the other states, fused their courts of common law and equity around the 1880s. So the English did it first, and then all the other states in Australia followed suit. New South Wales did not. It had a separate Chancery Court, Equity Court, until 1972. And I also think that is one of the factors which has led Australia to be such a giant in equity law and in trust law, because there was a whole bar and practice devoted simply to matters of equity and trusts.
I was particularly happy to see how in recent years, Katy, your scholarship has at times diverged from the classical topics of trusts and equity, which everybody has been writing on for the last 200 years, and you have concerned yourself with some of the more recent developments in trust law and practice that are in many ways revolutionizing the field, and that scholars like us, but not just us, should arguably respond to and engage with. And so you have published quite a bit of recent work about the use of protectors, trust appointors or trustee appointors, and other types of trust officers who are not trustees, however we might want to call them. So could you describe how such non-trustee trust officers are now used in practice in Australia, to the extent one can generalize?
Yeah. So I'd be delighted to, Adam. If I can just say how I got into this, I blame my friend Hang Wu Tang. He wrote an article on how one should look at the extremes of the trust if you really want to teach it well. And I thought, what an excellent idea. I'm going to go down this path. And then I realised at that time, which must have been 2010, I didn't know much about protectors. So I made it my business to know about protectors. And then I discovered that not many other academics in Australia, at least, were interested in protectors. And what I've subsequently discovered is that Australian trust deeds use officers in the nature of protectors, guardians, appointors, or they have other names for them all the time. But it hasn't really penetrated trust teaching or trust scholarship yet. So part of my aim as a scholar is to make sure that we look at that, but also to teach my students about it. So my students, when I taught trusts, got a little class, half a class, about how you can absolutely stretch the trust to breaking point. Is it even a trust anymore? Including descriptions of protectors and appointors. But how it's being used in Australia, we don't tend to use the term protector, though we tend to use the more traditional terms of appointor and guardian, as far as I can see, because we are, as stated, we went from one extreme to the other, we're traditional. But the roles that these people are playing are effectively protector-like roles. And the reason for this is, I think, the rise in corporate trustees, or trustees who you may not know so well, but you want to have some kind of control over what is happening with the trust. At least in the cases I've noticed also, quite often it's a family patriarch who wants to maintain some kind of oversight over the, some kind of oversight over the trust corpus and ensure that everything goes the way that they're hoping. This can cause problems. So in one of the articles I wrote, it actually came out of a question a practitioner asked me. So he had a problem with someone who was a guardian, and he did a Google search. He's a friend of mine. He did a Google search and he thought, what academics has written on this? And he came up with me and he's like, hang on a minute. I know this person. I'm going to ring her and ask her a question. The situation he had was a situation where there's a family trust and you've got the trustee and the guardian being different people in a relationship, and then that relationship breaks down. Each has the power to remove the other from office.
Lovely.
Yeah. So each has the power to remove the other from office. The relationship is broken down. What happens? Of course, each tries to remove the other from office and appoint themselves in the office. So we've got trustee saying, I remove you as protector, and we've got protector saying, I remove you as trustee. Now, I think I've noticed a kind of explosion of these cases from 2020 onwards in Australia. Questions about what protectors can do with their powers, what happens when there's a dispute between protectors and trustees. I don't think it was something that we actually saw that much of before, but I think we're going to have to look at it. At the moment in Australia, it's a case of quick draw McGraw. Whoever gets their deed, pulling the other one out first, wins. That's not ideal, I don't think. Because, well, I do think Australian courts need to think a little bit more deeply about that. Has the person who's exercising the power to remove the other from office exercised it properly? At the moment, we tend to look at it very formally. But I do think we need to take a bit more of a kind of administrative law point of view and think, what are the considerations which operated on the person's mind? Should we really be letting people, duke it out with a battle of the deeds? So in one of the cases I considered, it's called Cihan and Cihan, there's 6 different deeds where they're just removing each other. That's actually a father and son. The father seemed to have difficult relationships with all of his children. One piece of advice I'd give to practitioners is don't make the family patriarch the protector, no matter how much he wants to be. Get someone who's not a family member but very trusted, precisely so that this kind of stuff doesn't happen. I know that he wants to retain control, but it's not a good idea as a matter of practice, because if a relationship breaks down, if a family breaks down, you then get this kind of a fight about it. And I feel that Australian law is not so good at dealing with it. So in Cihan and Cihan, the judge ends up finding that the 6th and final deed was the one that was valid. And that's the one where both sons and the father all have a say in what happens. So it was a King Solomon solution in a way. They all get a say. But what if it hadn't been? What if one of them had managed to wrest control of the other one and just taken everything away and liquidated the trust? What happens then? So I do think that's the kind of litigation we'll be seeing more of in Australia.
I think that litigation's really important because the way that I read cases and the kind of practical impulses that you see flowing through those cases, as a legal academic and not a practitioner, that's how I kind of get a sense of things, is that although the protector is supposed to be there for when things go wrong, in a way, what was intended by putting a protector in place was retention of control for somebody, for the settlor, basically. Yeah. And actually, maybe there hasn't been that much thought to when things go wrong, what's going to happen, because it just leads to these problems. It doesn't make things simple. It doesn't make things safe or protected when you structure it in these ways, and maybe you should be structuring it a different way. Yep. And maybe after you've read all these cases, and obviously we can talk about other cases where having control as a protector or just having powers as principal family member, that's the famous name of the person who held the powers in Clayton and Clayton.
Yes.
That can be a danger for your trust. So, but it's sort of a funny thing where the protector's put in place. And it's this great thing where there's more protection for the settlor or for the trust somehow. And then it just still turns to custard in litigation, and you find that it's a stumbling block. Mm. But, one thing that this also makes me think of is this idea of protectors, in a way it came from offshore, or there was a strong thread of, we'll have these things called protectors because we'll have these funny offshore trusts where the beneficiaries don't have enforcement rights.
Yes.
And you're like, well, how can this be a trust then?
Yes.
And so it sort of makes a bit more sense there.
Yeah.
But from the perspective of onshore, and we don't have such trusts in New Zealand, in most other jurisdictions, onshore jurisdictions, it sort of adds to that complication of trusts. Like, you've already trusted the trustees. You've just selected them to be the trustees and to act in good faith, fiduciary obligation, all that kind of stuff. The beneficiary can enforce those, right? Why do we have to have this protector in there as well? It's an extra complication of, some people can't understand why we have these trusts anyway. I never understood when I was a student, but what do you think about those points?
So they're really good points. Some of our research together has been interviewing trust practitioners about why they make these choices. Why people do this is because while we don't have those kind of really crazy offshore trusts, asset protection trusts or star trusts, which are almost not trusts at all, we do have massively discretionary trusts. And from my conversations with practitioners, it is customary to give the trustee just absolutely enormous discretion. But then it almost becomes a shapeless trust. And then so the institution of a protector is designed to kind of put a bit of a shape on it to corral the exercise of those powers. But if you're not careful about who the protector is, it might work in the other way. But I also kind of feel like just throwing in massively discretionary powers, you can do whatever you want, is also problematic. Because actually you need to think about, are there limits to what I want done with this asset, right? Rather than being, it's almost a bit lazy, I want to be able to do whatever I want. Is there anything you don't want to be done with this asset? Is there any limit you want on it? Possibly put that in the trust deed rather than leaving it to chance and leaving it to disputes and family breakdowns and things like that. I feel that perhaps with more careful drafting and more considerations of the ways in which things break down, it might be better to draft a trust deed more carefully. But I also think that the more cases we have where things break down, the more trust drafting will respond to those situations. So you can see that in contract law as well. You have a situation, people go, oh gosh, I don't want that to happen. They draft clauses for their contracts. I think the same thing will happen in trust law as well. I think the more of these cases we get in court, the more thought will be put into, well, hang on a minute, what exactly am I doing here and what powers do I want people to have? And maybe just giving people utterly unconstrained powers, unlimited by anything, is not doing anyone a favour. Maybe we need to think about what we're really doing here. So that'd be my answer to it. But yeah, it seems to be an effort to deal with these absolutely hugely discretionary trusts to try and put some shape onto them.
So, moving from these very modern questions to something more classical but still relevant, I was wondering, which of trustees' duties do you see as being fiduciary duties, right? Because as often happens, there are several views about this. I mean, do you subscribe to the prescriptive duties only school, according to which only the no conflict and no profit duties are fiduciary duties? Or do you subscribe to the opposite school, which I've seen expressed by Justice Hayden of your High Court, who once said in print, I think, that every duty owed by a fiduciary is a fiduciary duty? Or do you prefer some sort of intermediate position, such as one reading of Lord Walker's statement in Pitt and Holt, according to which, if I understood him correctly, there are not two but three fiduciary duties, namely no conflict, no profit, and the duty of proper consideration?
Yeah. So thank you very much for this excellent question, Adam. One of the issues I have here is that I think that the term fiduciary duty actually has two different meanings. And that's what I've said recently in an article in the Journal of Equity published last year. So, at its core, the fiduciary duty, as I tell my students, is the obligation not to profit and not to conflict. And that's the irreducible core. If you don't have that, you don't really have a fiduciary duty or a trust. I'm Australian, so I do tend towards the prescriptive view. Sorry, Justice Hayden. Sorry, not sorry. But so I do tend towards Matthew Canaglan's view that fundamentally the trustees' duties are negative ones, and that there are sound economic reasons for this. There are reasons. What we're trying to do is minimise the risk of defalcation. There is another way in which the term fiduciary duty is used. And actually, the Privy Council recently, in a case called Dawson-Damer and Grampian Trust Company, which is last year, they said when Lord Walker in Pitt and Holt used the term fiduciary duty, he was using it in a broader sense. Basically, the way in which they read it was meaning a breach by a trustee or other fiduciary of its duty of proper consideration. So if you're exercising a power under a trust, you actually have a fiduciary duty in the broad sense to ensure that you exercise that power properly. So if there is an obligation under the trust to consider whether it's proper to exercise a power from time to time, then it's necessary to undertake adequate deliberation. You can't just do that kind of, I'm cross with you, I'm going to exercise this power. You have to think about what's in the best interest of the beneficiaries and the trust and things like that. And then if this duty is breached, Pitt and Holt establishes that the impugned transaction becomes voidable, not void. But I do think the use of the term fiduciary duty in this context is actually unfortunate, because I think it leads to different forms of what fiduciary duty means. I don't know if it's possible to come up with a different term that nonetheless encompasses the idea that what you're talking about is that a trustee has to exercise their power in the proper way with proper considerations. And that's what the Privy Council has recently clarified in Dawson-Damer. So yes, I tend towards the kind of prescriptive negative view of trustees' obligations. But there are obligations in the broader sense, which are sometimes described as fiduciary duties, but which I would say is something else. It's a duty to have proper consideration. And I think it's something that Australian courts, beg your pardon, I think it's something that Australian courts are going to have to think about more with all these cases about protectors and trustees coming up. Okay. Yeah.
Thank you so much. So, in other words, we are progressing towards a situation where we would have fiduciary duties in the narrow sense and fiduciary duties in the wider sense. So the mystery thickens.
See, I prefer to use not narrow sense, wide sense. Think of another word for that wider sense. What are we actually talking about here? Maybe it's a duty to properly consider or something like that, which flows still from the fiduciary office, right? And it flows still from the office of trustee. But, yeah, I'd prefer it be called another word.
Yeah, part of that to me seems to be, at least on a very superficial level, that the words labelling these different approaches, the prescriptive approach and the proscriptive approach, I always find some of these terminologies you find in the law where it's so close, and perhaps most people don't have any idea of use of those terms in ordinary language. Because proscriptive is the negative one.
Proscriptive, yeah. Oh, yeah, I've marked up prescriptive, and I always do. I've got to remember prescription. It's giving you something, right? I've marked up.
Yes, like a doctor does. And a proscription is something you may not do, such as don't be in a conflict.
Yeah, I take a proscriptive view. So,
You do.
Yeah.
We could try and do some clever editing, but we can just leave it in if you're happy with it.
Oh, no, I'm actually happy to leave it in because that just shows, okay, everyone makes mistakes.
Yep.
Everyone finds these terms hard to deal with. I'm not perfect. I actually think it's really important that students know I'm not perfect. Okay, I'll tell you a secret, not so secret. At law school, my lowest mark was in trusts.
Yeah.
Why was this? I went insane. I studied well beyond the course. I basically studied, did a PhD in trusts. I loved it so much. But I kind of lost the woods for the trees. And I took a bit of a wrong turning in the exam and possibly discussed things that no one else knew about.
I mean, I'm just recalling what I think it was the person who marked my property law exam as a student told me when I came to ask them questions after being unhappy with my grade. What she told me can be summed up in the brief saying, Adam, don't be a smart guy. Don't don't try to be too smart for your own good. And that resolves a lot.
Yeah, don't try to be. I now say to students, don't go and get those twiddly points that no one else knows about. I mean, yeah, it's clever. And if you do that in a court case and manage to convince a judge, that's fine. But in the exam, just make sure you get the main bones of it down. Don't get totally distracted by some random clever point, which, we may have a similar personality, Adam.
Yes, as we've noticed in the past. And I'll just mention one more example, I think, and an amazing example of this conceptual ambiguity that you noted, Mark. I mean, maybe this is slightly outside trusts law, but think of the term sanction. I mean, we both say, certain behavior is sanctioned in the sense of approved of. It's the right kind of behavior. But sanction also means punishment. So, I mean, the degree of overlap and confusion is surprising.
I have also a confession from when I was an article clerk, qualifying to be a lawyer. I mucked up, like I won the property prize, right?
Of course.
I mucked up the words mortgagee and mortgagor on 105 charge documents. I find that stuff really hard, hence proscriptive, prescriptive. It's like, oh. As long as people explain what they mean to me in an exam, I'm pretty forgiving. If they muck up mortgagee or mortgagor, I'll just kind of circle and go wrong one. But as long as they've got the concept right, that's what I care about.
Yeah.
I may be forgiving because what I want is the concept. And I'm used to, I've had experience of flipping these words before. Law is a difficult business. I think sometimes we're too hard on ourselves. And I also think it's important for someone like me to say, I don't always succeed. I don't always get it right. No one does. No one's perfect. So be it. And it means students don't think that they always have to be perfect either. But it also, like when students, currently my main subject is remedies, sometimes students come to me and say, I love this subject and I didn't do so well. So keep loving it. It can be just chance that you mucked up the exam, or maybe you were trying to be a clever guy, but it doesn't mean that you're not good at it. And it doesn't mean that it's not a subject of interest. And maybe you might end up a professor in it.
Yeah, couldn't agree more. And I think you wanting to share that is it's characteristic or emblematic of you wear your heart on your sleeve, and you do share a lot on your blog as well. And just so valuable.
But that's part of the thing, is just admitting we're human. Because I know when I first started out as an academic, the first 2 articles I published, just by chance, I got accepted without amendment. And I thought this was the norm. And
For you?
so for me, well, so then I sent off my third article and it was revise and resubmit. Oh my goodness, I was in floods of tears. Oh my goodness, I failed. Revise and resubmit. Off you go. Yes, you can have the chips. So if it keeps you away, you can have the chips. And then I spoke to my colleagues and they're like, everyone gets revise and resubmit, right? And I'm like, why does no one ever talk about it? I would feel so much better if people go, oh, I got revise and resubmit, and some of the comments were really awful. So I'm really honest with younger scholars. I'm like, this is something that happens to everyone. It's actually important to talk about this, or I went for this thing and I didn't get it. That's okay. Because people often don't talk about that.
Yeah, I'll even add another anecdote along similar lines, and then maybe we can get back to trusts talk. But I'll just say something I heard from a former colleague who got her PhD at Harvard, I believe. So she told me how when she was a fresh doctoral student, newly arrived at Harvard, very impressed by the world-famous professors, and about Cass Sunstein having 700,000 downloads of his papers from SSRN and everything. So she found herself sitting in the cafeteria close to another table where some of the most august, famous, big Harvard law names were sitting. And she overheard some of what they were saying. And to her amazement, the gist of these professor's conversation was, oh, I can't believe how my article was rejected. I can't bear it. And this is actually an instructive story, because even the people who are objectively the most famous legal academics, bar none, on earth, even they face these disappointments. And that's a sign of the system working well. Not badly. It's a sign of it's working well. So
Exactly.
That's the story.
So to get back to trust, with that one about protectors, I got reviewer comments which made it so much better. I'm really grateful to the reviewers for pointing it out. when the review system works better, it actually, because they were the ones who pressed me on, maybe you were a reviewer, Adam, but they were the ones who pressed me on, what do you mean by fiduciary duty? And I'm like, hang on, what do I mean by fiduciary duty? I've got to explain this. And that's how I came up with that whole idea of there's actually two different meanings to fiduciary duty. But that kind of criticism can be absolutely invaluable. Yeah.
So just on the topic of fiduciary duties and I guess other ways that trustee decisions may be reviewed, I mean, by analogy, we think about, okay, we've got the protector and are the same duties going to apply to them in terms of the powers that have been given, or is there going to be a mixture of different kinds of powers, some fiduciary, some non-fiduciary or personal powers? And that question can be very important in reviewing those decisions. What kind of review can you make of the protector's decisions? And often, some of the recent case law has been around that very question, but in terms of trying to say the review is so insignificant that this is not a trust at all, or the powers you hold, often because they're not deemed to be non-fiduciary, as protector or as principal family member, they mean that this is your property. We'll treat this as your property for certain purposes, largely marital or relationship property sharing. And so that quite tricky question that applies to the trustee, then we start having to say, does it apply to the protector? Bit of a classification question, really, because we know for the trustee, we just don't know exactly how to characterise these duties. Prescriptive, proscriptive, what are they? How does the court go about reviewing those? For the protector, it seems to be more, do they owe those duties, fiduciary obligations? And if they don't, how else might we review the exercise of their powers? So I just wondered if you had a few comments on some of those questions.
Yeah, so that's a great question. One thing I would, having talked to practitioners, one thing I would advise laws of trust deeds to do is turn their minds to that question and actually specify in the trust deed what kind of discretion they want a protector or a trustee to exercise. Because it's not good to have a shapeless power, a power where, you know, I can do anything I want, I am the master of the universe. Well, that can include some really bad things, right? So think about how you want powers to be limited, how you want people to exercise it, what kind of considerations you want them to take into account. With fiduciary powers, obviously you have to give more thought to whether it's in the best interest of the trust. You have to think about it more regularly. You have to justify the decisions you make. That might not be a bad thing. There seems to be an idea in this world that, lack of constraint is excellent. No, lack of constraint can actually be really bad, and if the powers are unconstrained enough, the trust may even cease to exist and you'll be in terrible trouble.
And the parallels to the political sphere seem clear.
Yes, I may have actually been thinking about that too. So, but absolute power that can be exercised in any way anyone sees fit, not necessarily a good thing. What we really want to do is talk about how we would like to see those powers exercised and what's in the best interest. So I would actually advise practitioners to turn their minds to these things rather than just simply presuming, giving these people unrestrained, totally free power is great. No, it's not. It can actually destroy your trust. And then you've got the problem, which both Mark and I have looked at, of people wearing multiple hats. So again, it's that often the family patriarch, and we've got Pugachev as the person who does this, where they're the settlor, the beneficiary, the protector, they're actually wearing all these different hats at once. And what Justice Burse says in the Pugachev case is effectively this is illusory because this is an Angora cat trust. So if you stroke down the fur of the Angora cat, it can look very skinny and sleek. Or you can puff up its fur and suddenly it's a very big cat. People are trying to do this with trusts. Oh, by the way, tax office, this is a very bulky trust. I don't actually own this property. And then for the purposes of actually dealing with the property, oh, I'm very sleek. I can slip through all these corners and I can still deal with this property as if it's my own property. And Kent Schenkel has said that trusts perform a magic trick, right, of separating out all the benefits of owning property from the detriments of owning property. So the beneficiaries get all the benefits and the trustee gets all the bad stuff. But there comes a point where you can't just always get the benefits and behave like you fully own the property. If you behave like that enough, the court will say, well, the whole point of a trust is that this is not at your full disposal. You have settled it upon someone else. And if you're treating it like you've got it at your full disposal, there's actually not a trust at all because you're not behaving as if there is a trust. So, yeah, I think that's probably correct. I'm on the same page as you guys with illusory trusts and the like. On that point, it was interesting. I just went to a conference in Taiwan, and often in civilian jurisdictions, particularly China, there's extensive settlor control, and the settlor can still even own the property, and it can be a trust. Actually, Israeli law has this issue as well, but leaving that to the side. And I was kind of arguing with some of the people there, like I was saying, that's not a trust. And they were saying, yeah, but if the settlor doesn't still own the property, they're not going to part with it. And I'm like, that's not a trust. That's not a trust. The whole point is you've got to give it up. You've got to, but they're like, oh, culturally, people don't like doing that. And I'm like, in that case, maybe trusts are not for them. Because the essence of a trust is giving it up.
I think there's a fairly broad academic consensus, at least along similar lines. So, for example, we have a forthcoming trusts conference here in Vancouver next month, and Lionel Smith has just written to me today to say that he will be giving a new paper entitled Black Magic Trusts. So, to our viewers, this is a legal field where you get to do papers entitled Black Magic stuff. So, and also, any of our viewers who has not read the case of Mezprom, Bank, and Pugachev, to which Professor Barnett was referring, should do themselves a favor and read that case. It's a decision of the English High Court from 2017.
It's fantastic. It contains, among other things, a failed relationship involving a scion of the Tolstoy family. Yes, that Tolstoy. So, and a big mansion in Chelsea and London. And, I mean, the fun never ends. So,
of course, according to some accounts, Mr. Pugachev was a major factor in installing Mr. Putin in power.
Oh, I just want to say something at this point, which is when I started to teach offshore trusts to my students, I called them evil trusts. Don't tell the offshore practitioners to whom Mark and I spoke, but I was like, class, do you want to learn about some evil trusts? So obviously Lionel and I have a similar view of this. Black magic.
I tend to sometimes be somewhat more permissive, that people come to different circumstances in life?
Actually, I am. So, particularly after speaking to practitioners, maybe we can go into this. So, Mark and I did some research where we ended up speaking to practitioners from offshore jurisdictions. And I also read an excellent book by Brooke Harrington discussing the kind of sociology of the offshore jurisdiction. It's a superb book, very well written. I have more sympathy for the reasons why people might do this. Like, some of the people are highly unsympathetic, right?
Yes.
But some people, they come from jurisdictions where there's no certainty, right? I mean, we can see in Iran right now, you've got disastrous things going on. You don't know if the government is going to suddenly turn around and expropriate your property. You don't know what will go on. So what you want to do is ensure that your assets are actually protected in some way. And then other more sympathetic reasons why someone might want to create an offshore trust is to get around forced heirship rules. So under Sharia law, for example, property under a will is dispersed in a particular way. Similarly, in civilian jurisdictions, a slightly different way. But you might actually want to exercise testamentary freedom or freedom of how your property is given after your death. And I have some sympathy for that. So not all offshore trusts are actually evil. I feel a bit bad painting them as such. They can actually have perfectly good reasons, and people might have real and genuine worries, particularly if they come from a country where the infrastructure is unstable, the government is potentially going to take their property or do dreadful things. So not all offshore trusts are necessarily bad. That being said, of course, there's people who try and do Ponzi schemes or try and hide their assets to get out of genuine obligations. As a kind of remedies lawyer, I do get bothered by the way in which trusts are used to avoid creditors. That's probably I used to be a banking lawyer, so that's probably with my banking law. When I practiced, I was a banking lawyer, so it's probably with my banking lawyer hat on. What? I can't get at that money. I can't deal with it. I have to fan myself. Yeah. If it's my client whose money that I'm trying to protect, obviously, when I was a banking lawyer, I would have taken the other view. My students are like, which view should we take? And I said, sorry to be cynical, but who are you advising? So that's the answer. Like, you should always consider the other side, but who are you advising? If you're advising the person who wants to protect their money, take a different view.
Yep. Absolutely. And maybe I'll ask one more question before we probably sign off. And that's a question about a specific situation we sometimes come across in trusts. And that's where trustees holding trust funds borrow some of those trust funds personally, using them for different personal purposes. So I'm looking at this essentially from a conceptual point of view. That would mean, assuming you're the sole trustee, that would mean being your own creditor, the creditor and the debtor becoming the same legal person. Is this possible? And if so, how does it work?
Okay, so you can probably see from my face already, I find it rebarbative. I find it, no, it should not really be done as a matter of principle, but also as a matter of pragmatics. I just think that is going to lead to disaster. So if you're both your own debtor and creditor, it seems to me conceptually utterly incomprehensible, right? You cannot be, oh, I'm going to sue myself for a debt. Like, although being a trustee involves the wearing of hats, You cannot wear too many hats at one time. And I think that's also something that came out of the Pugachev discussion. But you cannot wear both hats at the same time. So conceptually, that doesn't seem to work to me. But also, I would object to it on a matter of pragmatism. It just seems to me extremely dangerous for trustees to be borrowing trust funds. It seems to me that this is the kind of scenario which we should disincentivize, just as a matter of pragmatics and a matter of what trustees are about. They shouldn't be doing things with trust funds in their own personal interests, because the whole point is you don't do things in your own personal interests. Consequently, I'm strongly against that from a pragmatic point of view, but also a conceptual point of view. It's like a singularity. It collapses in on itself. It doesn't really work for me. So that's my view. Yeah, so I have quite a strong reaction to it. You might have noticed.
Yeah. I'll just say a few more words. Being that I've been told that this is actually quite a common situation, as, for example, where a bank, I mean, looking back to the start of your career, where a bank serves as trustee, you know?
Oh, no.
The situation, for example, a bank serving as trustee, paying itself or having due to itself some overdraft interest or other type of interest.
No. Okay, I would say to the bank, don't do it. They'd probably be upset with me, but I don't care. I'm sure they'd argue to me. I know exactly what they'd argue to me, having been what I was. They'd say, oh, but it's different arms of the bank, so it's effectively kind of two different people. I'm like, don't even go there. You know, just don't do it. If you're going to be a trustee, that means that you have certain duties, and you can't then do that other thing. From my point of view, it's a kind of disabling office, right? You can't then, don't be a trustee if you want to become a debtor. Just don't do it. If you're not prepared to disable yourself in that way. Anyway, so it horrifies me, and it strikes me as a risky practice. Yeah, as I say, my bank clients would probably not be happy with that advice, but bad luck. Part of your role as an advising solicitor is to restrain your client from their worst impulses and to say to them, don't run over that cliff. Don't put your foot in that big hole. Don't, for goodness sakes, borrow from trust funds. Yeah.
Thank you, Katy.
Yeah. So that's great. Oh no, I'm still feeling slightly unwell. A lot of people borrowing from themselves. Anyway, as a trustee. Okay.
We've hit time to wind up the episode after a real fascinating discussion of a number of issues in trust law, and we got at this theme of, you know, what is prudent and or legally advisable to do. We've been hitting that theme throughout, but yeah, thanks so much for all the insights that you've provided for us, not just on the law, but on life more generally. Also your ability to talk about human things in a human way, which sometimes lawyers struggle with.
So, yeah. Although, yeah, sometimes my husband's like, who actually talks like that when I say certain things? And I'm like, you know, insofar as blah, blah, blah. And he's like, until I married you, he's a scientist. I never knew someone really talk like that. You know.
Which explains how marriage is an educational experience.
Exactly. He's been educated. He's like, I now know about misleading and deceptive conduct, among many other things. So, but yes, such a pleasure to talk to you both today. And I look forward to seeing you both again soon, or speaking to you both.
Hope so, very soon. And thank you so much, Professor Barnett.
No, thank you both. Such a pleasure.